The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
Good morning. Happy Mother's Day, and welcome to Condo Craze and HOAs here on our YouTube channel. I'm Karen Curtis, and I am joined by attorney Eric Glazer, who is board certified in community association law. And we would be not here every Sunday at 11 a.m. without our sponsors, whom we love, and they are fantastic. But they offer you the best services in South Florida, including our diamond sponsor, Best Roofing.
Yeah, make no mistake, none of this happens without them.
I know.
Make no mistake.
And they've been with us for
forever.
What, for 15,
so honored
16
to have them all,
yeah.
really.
So I'm here again with Eric, and again, he's board certified by the Florida Bar and Condominium and Plan Development Law, which is kind of a hot topic these days, don't you know? Yeah.
You think?
And he's got a law firm here in Hollywood, Fort Lauderdale, and also another one in Orlando. Is called Glazer and Sachs. And we're here each week to answer all your questions and calls about things that make your life in your condominium or HOA absolutely crazy from 1 minute to the next. So we want to get the phone lines going early. And if you want to ask Eric any questions about the new condo laws, potential laws, it's a bill right now,
right.
Give us a call right here in the studio, 717-GLAZER-8 with a Z. That's 717-452-9378. And of course, you can ask us a question in the chat box as well, because some people do that, both of them, so that we get an answer for during the hour.
Yep. Hey, good morning, everybody. And don't forget to subscribe to two things. Number one, of course, the Condo Craze channel on YouTube, where we really built up an amazing library now. Of course, you can watch the show live, but watch the show at your convenience if you just can't watch it live. On any number of, how many you've gotten there? 200?
Yeah.
Yeah, the amount of hits we're getting, thanks to Robert, is kind of incredible. It's like every show's now getting 1,600 views. It's so flattering.
Several thousand, and your blog does well too.
Blog does well, and we didn't get the official notification from YouTube when it happened, but we're now well over 100,000 views.
Yeah.
So that's really flattering from all of you. We
Thank
really
you.
appreciate it. And of course, don't forget to subscribe to our email list, and you can do so by doing that by going to the show's website at condocrazeandhoas.com. By subscribing to the email list, you can get announcements about the show, new legislation, where our seminars are going to be, and a whole lot more. And we're on the socials, Karen, right?
Yes, we are. We're on Facebook, TikTok, Apple, Spotify, and also on X.
All right. As Karen was saying, we also do a blog that can be found every single Monday at condocrazeandhoas.com. And you can rest assured the blog topics over the next current weeks are definitely going to be about this new bill, because it's massive. And before we get going, some housekeeping stuff, of course. Most important thing is I first want to wish every single mother out there, including my wife, my mother, and of course you, Karen, a very happy and healthy Mother's Day. And really thanks for spending your time with us on a really very joyous day. And we promise we'll make it worth your while. And I also want to remind everybody that I'm going to be teaching this week in Orlando. We'll be doing the Condo Craze and HOA seminar starting at 8 o'clock a.m. at the L&L Condo and HOA Expo in Orange County Convention Center. Not too late to register. Just go to condocrazeandhoas.com. Haven't been in Orlando in a while, and I look forward to seeing everybody there. Always a great crowd.
Yeah, we get a lot of calls from Orlando as well.
Absolutely do. Central Florida, 100%. All right, so as we said last week, as far as condominium law goes, the Florida legislature ended the legislative session in a big way by passing one big condo bill. All right, it's not actually done yet. They're fighting about a budget.
They have no budget.
They have no budget, and that's the thing that they're mandated
That's what they're supposed to do.
Right, so they're still there, believe it or not, but they're not going to be taking up anything else in regards to condos, and they didn't take anything up in regards to HOAs. But like I said, this bill is massive, 191 pages. And last week we covered reserves, And to recap, we learned that reserves can now be funded with loans or special assessments. I wasn't too big. I wasn't certainly in favor of funding your reserves with loans, because you take out a loan the first year, the second year, the third year to keep funding your reserve account, and you're just paying back one loan after another with interest. I really
Use that
think,
the developer
this
makes
is a
out of
great
this.
bill for developers, because when people can't afford to repay their reserves that they borrowed year after year after year, what do you think is going to happen? Foreclosures are going to happen. So that's how I see it. It may work for the first year, the second year, the third year, but all of a sudden when the condo got massive loans built up because people didn't want to dig into their pockets to just pay the reserves, you want to talk about problems coming? There are problems coming. Remember I said that.
But if you've already done the Sears study, you
you could
can
waive
waive
it
your
for
reserves.
2 years. That's
2 years.
correct. You can waive it so that there's enough money on hand to actually make your repairs.
So maybe you don't have to borrow.
Right, I can get that. I can deal with that for the 2 years after. Not a bad thought.
Right.
So that you have money to actually, do your repairs.
But if you
But after
haven't
that,
done it,
I'm sorry, your other 8 years, you're borrowing money to fund your reserves. Good luck with that. I'm telling you, I'm not in favor of that one. But sorry, reserves was only one small part of the bill, and the bill is huge. Let me say that, huge. And in terms of analyzing it, finished it yesterday. Finally, the summary is 10 pages long, and I'll be giving that out to people that want it. And let's start with a provision dealing with conflicts of interest. Right, really important stuff. And here's what the statute says: any design professional or contractor who submits a bid to the association for performing any of the services recommended by the milestone inspection, right? So they're submitting a bid to do the repairs. They may not have an interest directly or indirectly in the firm or entity that provided the milestone inspection, or be a relative of any person having a direct or indirect interest in that firm, unless that relationship is disclosed to the association in writing.
Well, this sort of makes sense, right?
Yeah.
I mean, because possibly the person performing the milestone inspection won't say that lots of repairs are necessary if they know that they're not going to be the one doing the repair work.
Exactly, and that's
You
the
know what I
intent
mean?
of the statute, right? You want to make sure that the person performing the inspection do it with integrity, not with the hope that they wind up getting the job to do the repair work. So you want the two to be totally separate entities. So you don't have to worry or think about, wait, whatever I say, is that going to help get me the job to do the repair work? You want that milestone inspection totally independent.
I love that idea, but suppose the contractor and the person doing the inspection turn out to be related.
Okay, that can happen, right? Turns out that they didn't disclose it, and this is pretty amazing. Then the statute goes on: a contract for services is voidable and terminates. The association can actually terminate the contract upon the association filing a written notice terminating the contract if the design professional or contractor failed to provide the written disclosure to the association.
Family tree.
Yes, failed to disclose it. The association can say, sorry, you didn't
Well, how do you
disclose it,
find
you're
out if
terminated.
they're related?
That's a hard part. But it's, sometimes it happens, right?
Right.
You do Sunbiz searches and things of that nature, which you should always do beforehand anyway. Like when someone asks me to review a contract, let's say, for a contractor, first thing I want to do is I always make sure that, is this firm a registered firm in Florida? In other words,
contractor.
Right.
Are they licensed?
Are they in Sunbiz, right? Are they in? Is there a company called this?
Yes.
Right. That's registered with the Florida Secretary of State. Okay. Now that there is, now I check to see if they hold any licenses in the state of Florida. You'd be surprised how many times that the association, after the fact, tells me they hate their contractor, go sue the contractor, and I'll get the contract, and I'm like, did you bother to do a search to even find out if this person is licensed? They're not. Yeah, so now technically under the law, you're entitled to all your money back.
Oh, wow.
Right, and you don't have to pay for any bill that's outstanding if you did work that requires a license and they didn't have that license. So it's interesting. And I like it. I like not allowing unlicensed contractors to take money from the association for anything that they need a license for, obviously.
Of course,
Yeah,
you never want that.
No brainer.
So, you've read the new law.
Yep.
You comprehend the new law. Well, It's a bill. He hasn't signed it yet, right?
Correct.
Okay. So, and the Senate passed it, so
The
it's
Senate
just
passed
it's
it,
on his
House
desk.
passed it.
Okay.
The only 2 votes that were against the
Okay.
entire bill.
So there's a new law. Does it answer the question though? Does the state even know how many buildings even need to have a milestone inspection?
So-
how many condos
Right.
need to have this inspection, and then the reserves?
Up until now, right? That question was asked on the show, like, how does the state even know what's going on? So finally, this bill, to its credit, tries to get a handle on all this. And I'll tell you this, your building department is going to be very busy going forward. Look at the statute here. On or before December 31st, meaning this coming December, right? And on or before each December 30th thereafter, right? Every single year, your local enforcement agency, meaning, let's say, your building official, who's responsible for the milestone inspections, they have to provide the Department of Business and Professional Regulation in an electronic format determined by the department all this information, right? Every year they got to give the DBPR, the Division of Condos, all this information. You ready?
But doesn't the DBPR know about what buildings have a 30-year milestone
No, they
inspection?
do not. No, the agencies.
Well, then how did they know they even did it?
They here we go. So it's this year.
It's the first year.
The answer to your question is found in the new statute. Okay. Finally, everybody said, "Well, how did the DBPR even know?" Well, now they're going to know. Okay, because here's the information that every building official in the state, think about that, is going to have to give to the DBPR. You ready? You can read it off with me.
Okay.
You are ready?
Yeah.
The number of buildings required to have a milestone inspection. Again, all of this is going to be given to the DBPR. So again, number 1, the number of buildings that have a milestone inspection within their jurisdiction.
Okay.
Okay.
The number of buildings for which a phase 1 milestone inspection has been completed.
Okay. So
because there's 2 phases.
There's phase
and
1
you may
and 2.
not have to do phase 2.
Very good. So now anyone who did a phase 1, state is entitled to know who did it. Number 3, the number of buildings granted an extension, right? A lot of buildings said we can't do it within this time. Who did you give an extension to?
Because they can't find
potentially a licensed contractor
Okay.
to do it, right? Or architect or engineer.
The number of buildings required to have a phase 2 milestone inspection.
All right, makes sense. The number of buildings for which a phase 2 milestone inspection has been completed. And look how they're really taking charge of knowing exactly what's going on with every building that needs a milestone inspection and repair work in the entire state.
Again, the phase 1 is a cursory inspection of the building, and then they
Visual.
go, oh, we
Yeah,
need to have
yeah.
someone come in here and do it a little deeper dive into it.
If a phase 2 is necessary,
yeah,
right?
so
Correct.
that's where they actually like look into the concrete and see if
Chip
the rebar.
away if they need to, correct. Yeah.
So the number, type, and value of permit applications received to complete repairs required by a phase 2 milestone inspection.
Yep.
Are there any repairs after phase 1?
It's not required after phase 1.
Okay.
Phase 1's architect or engineer only says if you need a phase 2.
Okay,
Or
so
if
if
you
you
don't
got a
need a
phase
phase
1,
2.
you're good.
Right. If you pass a phase 1, you're good.
good.
Right. Exactly.
Yay.
Now, I always said if I'm the phase 1 architect or engineer, why would I
CYA.
say you don't? Right. Just in terms of covering my butt.
Yeah, good.
Why would I not say it's a good idea if you take a look for the phase 2? Because God forbid something happens to your building and I didn't recommend a phase 2.
Right. It's on
Man,
you.
that's serious liability. All right. The license. Oh, no, I'm sorry. A list of buildings deemed to be unsafe or uninhabitable as determined by a milestone inspection, right? Certainly the state has a right to know, okay, which buildings did you declare unsafe? Maybe they're going to do follow-up to make sure what happened with those buildings.
Right, exactly. Right? Okay. License number of the building code administrator responsible for milestone inspections for the local enforcement agency.
Okay, who's on the hook? Who's responsible for all this? And finally, the department shall provide to Office of Program Policy Analysis and Government Accountability. That's a long-winded word, right? OPAGA. All information obtained from the local enforcement agencies under paragraph A by the date specified and in a manner prescribed by OPAGA. OPAGA may request from a local enforcement agency any additional information necessary to compile the information and provide a report to the President of the Senate and the Speaker of the House. Long-winded, right?
So What does OPAGA do once it gets all the information?
I think what's going to happen is that they're going to print up all this information, and guy A is going to pass it to guy B. Guy B is going to pass it to C, C to D, and D right back to A. That's how government agencies normally work.
Do they give it over to the DBPR?
It's supposed to be given to them, and it doesn't say anything what they're going to do with that information.
But should it be accessed? Could we be able to access the information?
It doesn't say that.
I want to know if I can see it.
All of this should be accessible to you. But you'll see later on, there are parts of this new bill that require associations to put a whole lot up there with the DBPR, who will publish a site. But what OPAGA is going to do with that information, I don't know, because it doesn't say who shall have enforcement to do the following against buildings who are not compliant. It doesn't say.
They're going to know about it.
They're going to know, right?
But what can they do about it?
I guess they're leaving it up to your local building official to be the bad guy. I don't know, but we'll see. All right, let's hear what our viewers have to say. Give us a call here in the studio, 717-GLAZER-8. That's 717-452-9378. Call on in. Of course, you can also leave us a question or comment in the chat box on YouTube. When you call, if you want to wish Mom a happy Mother's Day, please start off with that. We'd like your moms to get a shout out during the show today. Okay, we'll be back right after this.
There are very large management companies, and there are very small management companies. And I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
Welcome back to Condo Craze and HOAs here on our YouTube channel. Happy Mother's Day. If you'd like to call and ask Eric a question about the new bill that's going to be signed that will change your life if you're in a condo, 717-GLAZER-8, or any question. If you want to just say Happy Mother's Day to your mom. Again, that's 717-GLAZER-8, 717-452-9378, or ask your question in the chat box.
All right, let's take our first call of the day.
First caller. Oh, it didn't leave a name, but when you hear a beep, you are live.
Good
Hello,
morning. Who do we
Eric,
got?
this is Amy from Miami. How are you?
Good morning. How are you?
Good, thank you. So I appreciate all your efforts to get these laws enacted. You've done a fantastic job, but unless there's effective enforcement, it doesn't mean anything. And that just doesn't exist now because, in one word, the DBPR is a joke. Mm-hmm. Now, I've filed several complaints for 2 separate associations because I have 2 condos that I own.
Right.
And all these remain, quote unquote, under investigation.
Yes. And
just for one example, after 1 year, one very serious complaint still remains under investigation, and that's regarding elections. Mm-hmm. There was a 3-page submitted for an election, and that person won by 1 vote. And now, 10 months after that complaint having been filed, it's still under investigation, but we're already into the next election season.
Right.
Oh, yeah.
So in fact, board has been making decisions for us, and many of them made improperly. And we've had a board member on that board who really got elected improperly as well.
Right.
So
Okay. So hold on
what
one
do we
second.
do?
You could have
Follow up.
filed potentially an arbitration action challenging that election too, right? But you relied upon the fact that there was a DBPR there. You relied upon the fact that the DBPR last year had their jurisdiction expanded, right? You relied upon the fact that you were being told that this is a brand new DBPR with a whole bunch of enforcement mechanisms now, and they doubled their staff to 72 investigators, something like that. And, you know, the unit owners around the state had hope that this was going to happen. I can only tell you one case that a client of mine also had. She wants me to talk about it, quite frankly, where I submitted proof from the association's own accountant, okay, from the association's own accountant, that there were financial misgivings going on. And I got back, I'm sorry, we weren't able to find anything.
Well, then you go to police, right?
I don't understand
Nope.
how. I served it up on a silver platter. And so, yes, I hear you. I really do hear you. And all I can tell you is I certainly made my complaints to the higher ups, believe me when I tell you. And all I can tell you is when things like that happen, you should complain directly to the secretary's office. And
Of the DBPR.
of the DBPR, yeah. Complain to the secretary.
What about the ombudsman?
They have no power over any of this, you know, really. Maybe their power was expanded a little bit, but, you know, their power is basically over elections. In this situation, yes, Karen, you'd be right, because the ombudsman's office is supposed to deal with elections. Did you submit this to the ombudsman's office? Good suggestion, Karen. Hello?
I filed online the complaint process that you can get online on the DPPR's website.
Yes.
And from there, basically, they reroute it to wherever it goes. You
Right.
lose control over it completely. I've made several phone calls during the year, and again, I'm constantly told it's under investigation.
Yes.
And that's it.
And that's it. I hear you. Since it's an election issue, you can also try the ombudsman's office. I agree. You might be able to go there, but you know, next time I can tell you if it looks like, you know, it's a pretty clear violation, you may want to actually file a petition for arbitration, or at least a letter saying you're going to file for arbitration if the matter is not resolved
Good.
within the next 10 days, and it'll make them think that you are going to file.
Right.
Merely filing a complaint with the DBPR, you're not going to get the relief that you want. I mean, I don't know what to say other than to say it direct. You're not going to get it, and you're certainly not going to get it within the time frame that you want to get it. Now, that being said, I have no idea how many complaints that they get during the year. I'm guessing it's tens of thousands, and you know, I don't know if they have enough investigators even with doubling the staff.
So does
But
the OPAGA thing take the onus off of the
It
DBPR
might
with the new law?
for those new things that we spoke about today, but it doesn't say that. It's actually it says just that the DBPR has to give them all this information,
Ah,
and they have to give it to the House of Representatives. It just looks like it's a matter of sharing the information. That's it. And it doesn't say who's responsible for enforcement. So in any event, when you have a matter like this going forward with elections, I would suggest doing exactly what I said. You got to go the arbitration route rather than the DBPR route. And I feel terrible saying that because they're supposed to be there for you for these situations. But
so
nobody's happy still,
You're
even though there's all these investigators.
you're
that
going
are
into
there.
arbitration with the board, not with DBPR.
You take the board to arbitration with the DBPR.
okay.
They're the ones DBPR is providing with the judges,
Okay.
the arbitrators.
Okay.
Okay, that's the only thing. It might not be the answer that you want to hear. Am I telling you to give up somewhat on the DBPR? I'm telling you not to rely on them in certain situations, especially where it's an election action and you need action quickly. Because just like happened here, what happens is you come around to the new election again, and then they tell you, "Oh, we'd love to help you, but it's now moot."
Yeah. Moot.
Okay, So you had all that aggravation, all the complaints, and for nothing. And if you think you're the only one,
Right.
sorry, you're not. Okay? But happy Mother's Day if you celebrate. Smile. Thanks
you.
for calling. Back to the phones, Ron.
All right. Next caller is Ralph from Fort Myers.
How are you, Ralph?
Good morning. Good morning. Hey, I am on the Florida Senate website, and they have created a bullet point list of items that are in the bill summary. And one of the things under official records, they are showing that a bullet point that recordings of meetings held by video conferencing are now an official record.
Yep.
So my question is it the audio and video portion, or is it just the video portion?
It's audio and video. I mean, the video is going to be pretty meaningless if it didn't include the audio, right? I mean, unless
yeah,
you had to read lips.
I'm saying if we just do the audio, do we have to now save this as an official record?
Yes, if you're doing a video conference,
we don't do the video portion.
Obviously it's not a portion of the bill that we got to yet, but we certainly will. Probably next week, I think we head on into that. But yes, if the board is doing video conferencing on Zoom, if the board is doing a recording, yes, that's going to have to be preserved now as an official record, I believe, for 1 year.
But he's saying they don't do the video part; they just do audio. Is you responsible for the video part as well?
Starting in July, if you're just doing the audio, no, it doesn't say that. If that's what your question is, right now, what the law is?
My question.
Hold on. Now, what the law is?
We don't do video. All we do is the conference call. Basically.
So now, what the law currently is? Hold up. Let me answer the question. So what the law is, and I believe what it will remain is, if you're only doing the audio, right? The audio you have to preserve until the audio becomes minutes, approved minutes of the association. And then once the minutes are approved using that audio, then the audio can be destroyed. Until then, got to be preserved.
By the way,
okay, yes,
I had audio that I had gotten through an interview, and I put it through AI, and it transcribed it in 20 seconds with the sound, cues as when it happened.
That is insane.
Yep. So there's your minutes.
There's your minutes. Wow, that's incredible.
Oh yeah.
I'll tell you.
The audio.
Yeah,
the audio as it is today, is that not in the law? That you are correct. It has to remain, or you have to have it until the meeting minutes are approved. That's already in existence, is it not?
That's correct. That's right. That's what I'm giving you, the current law. The new law, which is coming out, if it's signed, right, it'll go into effect on July 1, only refers to video conferencing. Video conferencing, like a Zoom call. Okay? If you're doing a Zoom call, does it have to be preserved? The answer is yes. That's what they're referring to. They're calling it video conferencing, but think of that as Zoom.
Okay.
They didn't say the word Zoom because there's several different carriers.
Well, they got rid of Skype.
Skype, right? There was another one that I used to
use.
Rob, not Constant Contact. There was another one I used to use all the time. I think it was a Microsoft version. You have Teams. You have a bunch of different ones. Teams. So, yeah, they're talking about if you're going to use any of that, yes, that's got to be saved. That's got to be maintained.
And this is for condos only, right?
Or for condos, correct.
Not HOAs.
That's correct. I haven't seen that in the HOA bill. There is no HOA laws this year. Okay?
You know what I'm curious about?
Yeah.
So if we were not recording our conference from audio, we are actually in violation. We're supposed to record it and save it.
No, I don't believe that there's a requirement to record it. I'm not saying that. We're saying if you're using it, if you're recording it, right? If you're doing it, there's an obligation to save it. Now, I don't think there's anything in the new bill requiring it, but I'll take a look again, okay?
Okay, gotcha. Thank you.
You got it. Thank you. Let's do this. Let's go to our bottom of the hour break. Keep the calls coming in, 717-452-9378. Callers didn't wish their mom a happy Mother's Day. What's going on here? You know what? I shouldn't let them speak unless they first wish their mom a happy Mother's Day. Keep the calls coming in. Keep the chat box full, and we'll be back right after this. Well, everyone has a mom. Don't tell me that.
That's what I'm saying.
Yes, absolutely.
Roomkiss Consultants offer the professional expertise to help condominium and cooperative communities provide safe, compliant buildings for their tenants. We have more than 170 Florida licensed engineers and architects who are experienced with local regulations and can assist with Senate Bill 4D compliance. We can help with milestone structural inspections, capital expenditure evaluations, structural integrity reserve studies, and developer transition reports. Focusing on energy, resilience, maintainability, and sustainability, our experts can help with every phase of the building life cycle. Contact us for inspections, building restoration, repair and remediation consulting, or mitigation after a catastrophic event.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion, or call us directly at 561-853-5463.
All right, welcome back to Condo Craze and HOAs here on our YouTube channel. And I just want to quickly ask you a couple questions from the chat box. First of all, is changing the roof in a condo to metal roof a material alteration?
Okay, so you would think it is. Now you're going from probably a cheaper material to a better material, right? You're going, maybe from a barrel tile or shingle roof to a metal roof now. The association directors believe it's a better material. And if they get a letter or a recommendation from an architect or engineer who says, don't put back the same material again, right? Because it's likely to fail. Whereas if you put a metal roof on, the metal roof is going to last 100 years. It's going to save the unit owners money over the long haul. And if you get that type of letter, I think, from an expert, I think that if we brought it to arbitration, the arbitrator will rule that you don't have to keep putting back the same thing knowing it's going to fail. And there's cases out there that say we want associations to take advantage of new materials, changes in science, and therefore it wouldn't be considered a material alteration. If you're going up, okay, if you're getting something better,
got it.
Going down,
different.
I would think it could certainly be a material alteration.
Anthony Dunn asks, is deferring of reserves after the milestone inspection or the Sears report?
It's under the new law. It would be after the milestone inspection. Okay, the milestone inspection comes out and says you need all these repairs, right? So the new law says, okay, we're letting you waive reserves for 2 years because your milestone inspection is making you do all these new repairs now.
What's the difference between the milestone and the
Sears is just a breakdown of what you need to do with your reserve account going forward. Okay. Your milestone inspection is saying, hey, you have to do all these repairs now. So, and it's going to cost a lot of money.
Which is in the Sears report?
No, which is in your milestone inspection report. Okay, your milestone inspection report comes out and says you have to do all these things, right? Your building's a mess. Okay, you must make these repairs right now. Okay, it's given to your building official. Your building official is going to make you do these repairs right now. So as a result of that, the state has said this new bill, you're going to now need a lot of money to make those repairs. So as a result, we'll let you waive reserves for 2 years. So we want you to have the money to make the repairs over the next 2 years. That's the bill.
Okay.
Okay? All right. We got a caller up?
Yep. Let's go to John in Dania Beach.
Hey, John.
Yes, good morning, Eric. Good
Hey,
morning,
John,
Karen.
how are you?
Hello?
Yes, how are you?
Yes, hey, good morning, Eric. Good morning, Karen. First of all, happy Mother's Day to all the mothers out there. And everybody, thank God that your mothers were pro-life. Two quick questions I have for you, Eric.
Yes.
One is our wonderful board refuses, after repeated requests, to enforce our rules and regulations. This is an HOA.
Yes.
What can we do about that? Are we going to have to go? Am I going to have to sue them?
So you have to take a look, John, at what the bylaws of your community say, because we get this type of call a lot, and where my board isn't enforcing anything. Take a look at the language, and does it say, or it maybe even be found in the declaration, that your board shall enforce the laws of the community, shall enforce the rules, shall enforce the regulation, or does it say the board may? The board may. Now, there's a big difference, obviously, between the two. And if the language of your governing documents say the board may, then I think you're going to find that an arbitrator was going to hold that their board is given some discretion in terms of whether or not they have to enforce it. May is a completely different word than shall. So, before we start suing anybody, maybe you just want to take a look at what the governing documents say, especially your bylaws.
I will, and I'm 98% sure that it says shall. And if it does say shall,
okay, if it does say shall, yeah.
Then do we have to go to arbitration?
Yeah, or at least in an HOA, you probably have to start out at the pre-suit mediation table. So, you'd have to send them that letter where you pick 5 mediators. You have to explain the nature of dispute. You put down 5 mediators on the page, and then they have to choose one of those 5 mediators. And then you go to mediation, see if you could work it out. If it doesn't get worked out at mediation, then you wind up going to court, and whoever wins in court is paying the fees and costs of the mediator, the attorney's fees, and the fees and costs for the litigation as well. So you got to make sure you're right. Otherwise, it can be very expensive.
Gotcha. Okay. Second question.
Yes.
We have pooled reserves, and we're going to need to paint our building here in the next few years.
Yes.
And of course, we have no painting reserve. So there's no itemized line for painting. So when I asked at the recent meeting, guys, how much do we have allocated? What's our line item for painting the building? And the answer that I kind of expected I got, well, we have pooled reserves, so we can use those pooled monies for anything that we want. And I'm saying, look, if you don't have an itemized line in your budget for painting the building, can you then use pooled? Can you
No,
then take
you cannot. That is a
pooled
great
reserves
question.
and put it into a line item that doesn't exist?
You're 100% right, John. When you decide to use pooled reserves, you throw everything into one bag, one pot. You can only take funds out of that bag or out of that pot if you've been reserving for that item. And if they haven't been reserving for the painting of the buildings, right, they cannot take the money out of that pot, out of that bag, just because you're using the pooling method. Period. They can't touch it. Okay? Unless they're going to get a vote of the owners in order to do that. And now it's going to be 51, or a majority of all owners. A majority. It used to be a majority of a quorum. Now it's a majority of everyone.
That's kind of what I thought. And real quickly, Eric, if I could, one more question. If you could just maybe give an update, the good, the bad, and the ugly of your electric vehicle at this point.
Love it. I got to tell you, I love it. I have the Lyric, and the only thing that, of course, you're not crazy about yet is if you want to take a long trip. I haven't done that yet where, I'm going to look for charging stations and stuff like that. I don't want to be...
It takes a long time to charge it,
Yeah,
right?
and I don't want to be bothered with that. But if your daily life is just going back and forth to work, and the truth is if you can pull up to your house and just take the hose out and put it in your car, it's the easiest thing in the world. It couldn't be simpler. And I love the fact, not for money, and not because of saving the environment, forget that. I just love the fact that I don't have to go to a gas station.
Right. And
You know,
so
I
you're
hate
in an
going to a guest-
HOA.
I'm in an
They
HOA.
installed you. They paid you to
No,
install the.
the Cadillac actually gave
paid
you money.
to
We're-
install it, and it was
yes.
okay with the HOA.
It's right where I park my car. I
Boom.
walk over to my hose. It's 3 feet from my car. Put it in. The easiest thing in the world. Love it, John.
Wow.
And by the way, good. Okay, pool reserves, real quickly. Pool reserves have to be paid back. So if I borrow from the, I don't know, the road repair reserve, and I put a roof on, I have to pay that money back, correct?
Well, when you do your reserve study again, your reserve study is going to now look and say, hey, you have no money in reserves. We got to start funding things again at a quick pace. Okay?
Right. Okay, thank you all. I
Thanks,
appreciate all
John.
the information.
Appreciate the phone call
Great
like
show.
always. Let's take our final break of the hour. Keep the calls coming in, 717-452-9378, or drop us a comment or question in the chat box. We'll be back right after this.
In South Florida, the transition from bright sunshine to heavy rain and hurricanes can take a toll on your property's exterior and structural integrity. Cracked stucco, spalled concrete, they're more than eyesores. They can signal deeper issues. Now, with new Florida laws involving structural integrity requirements, we want to help you meet your milestone inspections and maintain the durability and beauty of your building. Since 2004, PD has been the trusted expert in structural concrete restoration, painting, and waterproofing for condominiums and commercial properties. Visit pd-concrete.com or call us today.
Life is full of steps. We learn to take small steps and big steps. We take steps toward adventure, to discover what's next. At South State, helping you take each step is what inspires us to keep moving forward, so you can keep enjoying what's next in your life. This is banking at its best. This is banking forward.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
And welcome to the final segment of Condo Craze and HOAs on this Mother's Day. Happy Mother's Day. And Eric, who is board certified in Community Association Law, taking your calls right now. If you have any questions about the new bill, about condos, or anything HOA or condo related, 717-GLAZER-8. That's 717-452-9378.
And
or
there
you can
is
ask
the
in
monster. Yes,
Oh, there it
there's
is.
the monster up on the screen right there. 119 pages, not one word of it devoted to HOAs, just condominiums this year. So I think, well, maybe 1 or 2 provisions also applies to cooperatives, but nothing for HOAs. That's the bottom line. Okay, back to the phones. Who do we got, Rob?
Let's go to, I think it's Barb, Delray Beach.
Mrs. Streisand,
Yes,
you're on.
hello. Hi, this is Barb. Can you hear me?
Yes, how are you?
Great. Thank you for taking my call. Happy Mother's Day, everybody. I'm from Delray Beach, Florida, in a condo, and I have a question about constitutionality of this new bill. There was an article that I wanted to post or bring attention to on 4/28 of 25, written by the Palm Beach Post, and the title was Florida Condo Crisis: Legislators' Two Approaches to Fixing Association Financial Woes. And there was a few quotes in there by an attorney, and it really struck me. Can I just read a few paragraphs real quick?
No.
From another attorney?
Florida Condo Crisis. Hello?
Yes. No, we're not going to read
Florida
paragraphs
Condo
on the air.
Constitutional.
From the Palm Beach Bugle?
Say
No.
again?
Yeah, no, we're not going to read paragraphs on the air. I can't let you do that. But if you had to give me one sentence as to why it's unconstitutional, What's the answer?
Well, it says that the bill might, okay, let's see. It just basically is saying that that there's an association decision, that okay.
Well, let me hold on. Let me make your life
nutshell.
easier, okay?
But,
Rob, just turn
okay,
it off for a
let
second.
me just try to paraphrase it. Any owner might be in court arguing that injury happened to him or her as a result of an association's decision to rely on a potentially unconstitutional law to take a loan or to get a line of credit or or allow for termination procedures, removing it from the condo form of ownership, and that this could be sort of a dark cloud for the owners, that there could be a lawsuit arguably that they've done takes away the property rights.
Okay, good. Yeah, and Karen, we started to actually talk about this during the break. Okay, I'm going to answer that question, but Rob, just turn it off so I can actually answer it. So we were talking about this. Karen asked me, well, what about all the Kaufman language stuff? What applies? What doesn't apply?
Or has anyone brought it up to you that we don't have the language?
Well, she just did, in her own way, right? So there's all these new laws, right? Last year, a ton of HOA laws. This year, a ton of condo laws. Now, let's say, for example, that your condo declaration, right, says you get to waive reserves every year if you want. The people in your building, as long as they get the vote, they get to waive reserves. It's how you want to live, right?
And it's in your
That's
deck.
in your contract, right? The unit owners have this contract, that their contractual rights to waive their reserves. Well, here comes this new law that says, screw your documents. They don't mean anything, right? Tear them up. Nope, from now on, you're funding reserves. Well, wait a minute. I argued the Cone case in front of the Florida Supreme Court. And the Florida Supreme Court says virtually no degree of contract impairment is allowed in the state of Florida. Well, so therefore, that law doesn't apply to me. You are really impairing my contract. You're making me now pay thousands of dollars extra per year that the unit owners in this building say they don't want to pay.
And we can waive them.
Right. This clearly impairs our contract. Well, the other side says, yeah, but it's a safety concern. I don't think the Florida Supreme Court cares one way or the other about if you want to take care of it.
They didn't in your case.
Yeah, they did not care about anything. There's no degree of impairment that is tolerated, says the Cone case. Okay. Now, can I promise how if an association took this to court, or someone, let's say an association did not collect the reserves, they let everybody waive it, and somebody in the building sued for not mandating reserves, and the case was filed in court? Can't tell you how it's going to come out, but you want to know the truth? I would rather represent the association and say, you're impairing our contract.
And this is a contract, that does not have Kaufman language.
This is correct, Karen. This is one that doesn't have Kaufman language, right?
If it does, you're going to have to.
If it does have Kaufman language, you have to do it. If it doesn't have Kaufman language, I kind of left out the most important part.
You did. I was like, wait a minute.
Right. If it does not have Kaufman language, which is as amended from time to time language.
So that means you have to go with whatever the lawmakers have
right.
done.
But if you don't have as amended from time to time language,
your deck is bigger than what the lawmakers tell us to do.
That's exactly right. And that's what this young lady was saying. Exactly. I don't know. Does the association want to try it? Let's do it.
Hire you because you want to go back and
let's take the case up to the Supreme Court. I mean, if that was their position then, it should be their position now. But would their position change in a post-Champlain Towers world and require reserves? I don't think so, to tell you the truth.
So what is happening is that many condos have no Kaufman language in their documents, and none of this applies to them.
Well, how about this one? You know what I'm getting asked for the first time now? We have Kaufman language in our declaration. We want to take it out.
How do you do that?
The vote to take it out. Now we don't have it. We want to go back to when the condo was built, so we don't have to listen to these laws.
Can they do that?
I don't know. We're going to find out because there's certain condominiums that are going to try it.
Well, you could have the right to change your decks.
Absolutely, you do. Certainly, you could amend your declaration.
So you could.
Why can't you take it out?
Take it out, and then you don't have to deal with it.
Again, that we're saying all these things, not knowing 100% sure what the answer is. But I got to tell you, based upon how strong Florida is in saying no degree of impairment, none is tolerated, I think I'd rather have the association's case.
And that was the case you argued in front of the Supreme Court and completely devastatingly failed at.
Yes.
Flat-footed, flailed.
Why don't you let it go now? You know what I'm saying? It was close, 7-0.
Yes, but how interesting.
How interesting.
That now, that very same argument
Right. If
applies.
I went back, remember the time you ruled against me 7-0, right? And you said no degree of impairment is tolerated. Well, then you can't force reserves down everybody's throat.
And they can take
if
the
their
language
deck allows them to vote against reserves. Is it a winning argument? I think there's going to be an association out there that's going to challenge it, rather than potentially have dozens and dozens and dozens of units go into foreclosure. So we'll see.
There's questions in the chat box about investors being like really
You want the answer?
opportunistic.
How do you get investors not to, take over your community? Very, very difficult. One thought is investors come in and they like to rent their units out. So, one thought is no rental for the first 2 years. So that might keep that might keep certain investors out. There's also some case law that we won for the Flamingo South Beach condominium, which basically says, and we'll kind of summarize it real fast. Once a property gets turned over from the developer to the owners, right? It's called turnover, right? And that property could never go back to being controlled by a developer on the board, okay? Can't be board controlled by developer. And what makes a developer under the law? Are they leasing or selling units in the ordinary course of business? So if this
you're saying
developer
as opposed to being an
comes
investor.
in, right? If a developer comes in and now all of a sudden is leasing their units in the ordinary course of business, and they think they can control the board, they're wrong. Okay, we want a really good case about that because there was Kaufman language. Okay.
So you're saying a developer can turn over the building but still own units?
No, a developer can turn over the building, and once a developer turns over the building, another developer cannot can come back in. And if they meet the definition of a developer, no, they don't get 2 out of 3 seats on the board. No, they don't get 3 out of 5 seats. And what's the importance of that? When a new developer comes in, like an investor, what do? They put themselves on the board. And what typically happens? Man, we need massive repairs here. We need massive special assessments.
And they price everyone out.
$20,000, $50,000 per special assessment. Price everybody out. Who's there to buy their units? The new guy. So there's a case out there that we won that may be able to save a lot of people. Okay? Back to the phones, Rob. Who do we got?
All right. Next caller is, it looks like James from Fort Myers.
Hey, James.
Good morning. 2 quick questions regarding the association meetings. I have the Senate summary of the bill, and if it's correct, it indicates that there will be a prohibition on board members from participating in meetings by video conference more than 2 times in a calendar year. And there's a second provision that says that allows board members who appear by video conference to vote, but their presence may not count towards a quorum.
I'm not sure if you're reading the bill that actually passed. I don't think you are, quite frankly.
Yeah, everyone seems to be reading the summary of bullet points on the Senate.
Yeah, stop feeding the bill into ChatGPT or whatever. Don't read the summary of the bill. That summary of the bill was originally put up there when the original bill was filed. So stop reading the summary. You have to go back and you have to click on where it says, you see where it says bill text?
Yes.
Keep going down, going down, going down.
So you need the latest one.
And you go down to bill text and you have to click on the word enrolled, right? And when you click on the word enrolled, that's what actually became the law.
Yeah, you're reading just the Senate version.
He's reading this, why I filed the bill and the general provisions of the bill.
Eric, I'm not reading that. Excuse me.
Bullet point.
I'm reading I'm reading a report, immediate release on April 30th, 2025, from Senator Ben Albritton as President of the Senate, saying what the bill, as it passed the Senate, contains.
Well, the bill that wound up becoming the law does not require that.
It's right
so
here.
yeah, I mean, unless
Can we put that up?
yeah, I mean, yeah, there it is. So
No, but I mean for them.
oh, I see. Can you put this up for, yeah, for people to see it? Yeah, but again, I don't believe that's the version that passed.
Here it is, right
I'll
here.
go back
Right
and
here.
I'll look again. Yeah, but I don't see anything in the bill that makes a limitation.
Defining the term video
Yeah,
conference.
this is the you can the term is defined in there, but there's not a limitation. I didn't see a limitation. So, you know, if you can find it in the actual bill contents of itself, and then lead me to the page, then I'll certainly say I was wrong, and tell everybody that you know what the law says and if you were correct. But I didn't see it that way. That's for sure. Okay.
All right. Appreciate it. It's 190 pages. Or
yeah,
something,
exactly. And I
posted.
went through 190 pages, I promise you. And I didn't see that portion of the bill that only allows a director to do it twice. And I think it's
thank
the
you.
reverse, quite frankly. I think that the legislature wants to encourage video conferencing because it allows for more participation. Okay,
Yeah.
that's what I think. Where the Senate and the House possibly were heading. They wanted to encourage more participation. What did we learn during COVID? Right? People participate on Zoom. Zoom
Yeah.
became an amazing thing. And
teachers found out that parents were watching.
yeah, right. But this is, yeah, I don't see a limitation. But if I certainly will say I stand corrected if you can tell me.
Well,
Okay.
one more sentence. You started the program by indicating that you had a 16-page summary. Where is that
10-page summary. Send me an email, and I'd be glad to send it to you. Eric at glazersacks.com. Again, Eric at glazersacks.com. Okay?
Thank you.
All right. That brings us to the end of another show. Today went perfectly. Rob, good job there. All right? Much appreciated.
The mother of all shows.
The mother of all shows. I'm glad it worked out this way. Again, to everybody out there celebrating Mother's Day, I wish you a happy and healthy Mother's Day. And of course, if you need legal assistance off the air, give our firm a call, Glazer and Sachs, 954-983-1112. Again, 954-983-1112. And we'll see and speak to you again next Sunday at 11 a.m. on CondoCrazeandHOAs.com. Thank you, Karen. Thank you, Rob.
Thank
and we'll see
you.
you guys next week.